In February 1964, the military junta governing Ecuador granted Texaco Petroleum Company, or Texpet, a vast concession spanning approximately 1.5 million hectares deep within the Orient region of the Ecuadorian Amazon. This pivotal agreement initiated Texaco's oil exploration and extraction operations, which would continue for nearly 3 decades until 1992. The area, centered around the nascent town of Lago Agrio in Sucumbíos province, was a pristine rainforest, soon to become the epicenter of one of the most protracted environmental legal battles in history. This marked the beginning of Texaco's extensive footprint, forever altering the ecological and social fabric of this remote Amazonian territory, setting the stage for an environmental disaster. From 1964 to 1992, Texaco's operations in the Ecuadorian Amazon, initially as part of the Texaco Gulf Consortium, were extensive. The company drilled 339 wells across 15 petroleum fields, leaving behind 627 toxic wastewater pits. Satellite imagery later identified 990 such pits, with Texaco ultimately responsible for over 1,100 environmental waste sites across Orellana and Sucumbíos provinces. Texaco admitted to discharging over 18.5 billion gallons of toxic water, an estimated 4 million gallons daily during peak operations, directly into the rainforest, without treatment, a practice that starkly contrasted with emerging industry standards of reinjection. This extensive dumping generated immense environmental harm. By 1993, the extent of the alleged contamination spurred action. On November 3, 1993, a class action lawsuit, Aguinda via Texaco, was filed in New York federal courts. This suit represented approximately 30,000 Ecuadorian citizens, including indigenous peoples from the Cofan, Sayona, Secoya, Guarani, and Quechua nationalities, alongside settlers from the Orient region. They sought $1.5 billion in damages, claiming massive pollution, environmental destruction, and elevated cancer rates. Texaco, now facing these grave accusations, successfully argued for the case's transfer to Ecuador, promising to abide by the local court's decisions, a move that would dramatically alter the legal trajectory for decades. Following the U.S. Court of Appeals for the Southern District of New York's decision on August 16, 2002, to transfer the case, the legal battle officially moved to Ecuador. On May 7, 2003, the lawsuit was refiled in the Superior Tribunal of Justice of Sucumbíos, located in Lago Agrio. Leading the charge for the plaintiffs were several key figures. American lawyer Stephen Donziger, born in 1961 and a Harvard Law graduate, became the lead American counsel. Alongside him was Pablo Fajardo Mendoza, an Ecuadorian lawyer from Lago Agrio who rose from humble beginnings to lead the local legal efforts, and Luis Llanza, born in 1962, of Cofan descent, president of the Amazon Defense Front. These individuals represented the hopes of thousands of affected citizens seeking justice. As the Ecuadorian trial progressed, the court appointed an independent expert in 2007, Ecuadorian geological engineer Richard Cabrera, to assess the environmental damage. His comprehensive report, submitted in April 2008, detailed alarming findings. Cabrera's team detected hydrocarbons at levels deemed unsafe by national standards in 44% of water samples. They also found significant concentrations of cadmium, barium, lead, and other heavy metals in the sludge of wastewater pits. The report concluded with a recommendation that Chevron, which had acquired Texaco in 2001, pay between $8 billion and $16 billion in damages. This expert opinion would become a cornerstone of the plaintiff's case, yet its independence would later be fiercely challenged. After years of proceedings, a monumental decision came on February 14, 2011. Judge Nicolas Zambrano in the Lago Agrio court delivered a verdict finding Chevron guilty of environmental contamination. The initial award was a staggering $18.2 billion, including $8.6 billion in punitive damages, with a provision for reduction if Chevron issued a public apology. Chevron fiercely contested the ruling, arguing Texaco had completed its remediation obligations and received a full release from the Ecuadorian government in 1998, placing responsibility solely on Petroecuador for any ongoing pollution. Despite their objections, an Ecuadorian appeals panel upheld the judgment in January 2012, affirming the lower court's findings against Chevron. In a dramatic legal countermove, Chevron filed a lawsuit under the Racketeer Influenced and Corrupt Organizations Act, or RICO, in February 2011, in the U.S. District Court for the Southern District of New York. Chevron alleged that Stephen Donziger and his associates had engaged in a fraudulent scheme, including extortion, money laundering, and witness tampering, to secure the Ecuadorian judgment. A key testimony came from former Ecuadorian Judge Alberto Guerra Bastidas, who initially presided over the Lago Agrio case. Guerra testified for Chevron, admitting he received thousands of dollars from plaintiffs' lawyers and Judge Zambrano, claiming involvement in a bribery scheme and ghostwriting judicial orders, including the final judgment itself. This testimony aimed to dismantle the very foundation of the Ecuadorian verdict. The RICO trial in the U.S. proceeded without a jury in October 2013, presided over by U.S. District Judge Louis A. Kaplan. Chevron presented a formidable case, including 24 witnesses and over 3,000 exhibits. Digital forensics expert Spencer Lynch testified, revealing metadata from Donziger's hard drive showing drafts of the Cabrera report, and even judicial orders were modified by plaintiffs' lawyers. On March 4, 2014, Judge Kaplan delivered a devastating ruling, declaring the $9.5 billion Ecuadorian judgment a product of fraud and racketeering activity, rendering it unenforceable in the United States. Subsequently, Stephen Donziger was disbarred in New York in 2018 and, after years of house arrest, was sentenced to 6 months' imprisonment in October 2021 for criminal contempt of court. The legal battle extended beyond national borders, with Chevron initiating international arbitration against the Republic of Ecuador under the U.S.-Ecuador Bilateral Investment Treaty at The Hague's Permanent Court of Arbitration. The tribunal ruled that Ecuador had, through agreements signed in the 1990s, released TexPet, and by extension Chevron, from liability for public interest or collective environmental claims. Furthermore, an unscitral tribunal found the Ecuadorian rulings contrary to international public policy, demanding no recognition or enforcement by any state aware of Ecuador's denial of justice. Attempts by the plaintiffs to enforce the Ecuadorian judgment in Canada, Brazil, and Argentina were all dismissed, highlighting the immense difficulties of cross-border legal enforcement against a backdrop of fraud allegations. Despite decades of legal wrangling, the human cost in the Ecuadorian Amazon remains profound. The approximately 30,000 plaintiffs, including indigenous peoples and settlers, continue to grapple with the devastating health impacts. Reports indicate alarmingly high rates of cancer, including uterine cancer and leukemia, chronic skin lesions, and lung disease. Miscarriages are 150% more frequent, and child malnutrition affects 43% of the population. Cancer alone accounts for 32% of all deaths in the affected areas, 3 times the national average. Unremedied toxic waste pits and contaminated rivers persist, a stark reminder of the environmental disaster and the community's ongoing struggle for a clean environment and justice. The Chevron oil spill in Ecuadorian Amazon case, widely considered one of the worst oil-related environmental disasters globally, has left an indelible mark on international law and corporate accountability. It serves as a stark cautionary tale for multinational corporations operating in developing nations, underscoring the potential for long-term environmental liabilities and the complexities of corporate social responsibility. The U.S. RICO ruling against Stephen Donziger established a significant precedent for challenging foreign judgments based on fraud in American courts, earning the case the moniker "legal fraud of the century" from the Wall Street Journal. This ongoing saga continues to shape discourse around human rights, environmental justice, and the enforceability of international judgments, with no final confidential settlement ever reached.